Hello everyone, my name is Andrew Colvin, and today I'm going to talk to you about the Titanic. The Titanic was the largest operating ship when it was launched on May 31st, 1911. It was 269 meters long, roughly equivalent to putting four of the world's largest passenger jet, the Airbus A380, end to end. It was carrying 2,224 passengers and crew on its maiden voyage on April 10th, 1912. It set out from Southampton, England to New York, New York. 4 days into this voyage, at 11:40 ship time, it hit an iceberg 600 kilometers south of Newfoundland. The ship sunk within 2 hours and 40 minutes, killing more than 1,500 passengers and crew. We are going to examine the ethical and legal issues involved with the Titanic from the perspective of a modern engineer in Ontario. At the time the ship was built, there was a shortage of both time and materials. The engineers working on the ship knowingly used a type of steel that contained a high amount of sulfur. The high amount of sulfur made the material more prone to fracture, especially at low temperatures. By knowingly using this inferior material, the engineers demonstrated professional misconduct by failing to satisfy Section 72.2b and 72.2f of the Code of Ethics, which define professional misconduct as the failure to make reasonable provision for the safeguarding of life, health, or property of a person who may be affected by the work, and the failure of a practitioner to present clearly to their employer the consequences to be expected from a deviation proposed in the work if the professional engineering judgment of the practitioner is overruled by a non-technical authority. They also failed to satisfy Section 77.2i, which states that the practitioner must regard their duty to public welfare as paramount. Additionally, the engineers failed to adhere to the common practice of using a double hull in ships that made Atlantic journeys. This practice has existed for more than 50 years when the Titanic was built, yet it was not implemented on the Titanic as it was intended to be a luxury ship. Because of this overemphasis on luxury, common safety was ignored, making the ship vulnerable. The engineer who made these decisions demonstrated professional misconduct as defined by Section 72.2a, b, and f. After the Titanic disaster, its sister ship, the Olympic, was retrofitted with a double hull. Two other issues that contributed to the Titanic's disastrous failure were the fact that it had only half as many lifeboats as it did passengers, and the fact that the watertight float compartments were not sealed at the top. Neither of these are ethical issues so much as they are regulatory issues. In the case of the lifeboats, the Titanic actually had 10% more than what was legally required at the time, and in the case of the float compartments, it was standard practice to not seal the tops of the chambers. Both of these regulations were changed shortly after the Titanic disaster. In this scenario, the engineers should have raised the issue with their immediate supervisor and raised the need for more testing on the materials used in the ship. If the company follows through and solves the issue, everything is good. You have protected the public's welfare, and the company remains in good public standing. If, however, the company does not follow through and fix the issue, you will have to consult PEO and go through the process of blowing the whistle. Alternatively, you could approach a regulatory board with the issue. In both cases, you would likely lose your job, and the company's reputation would be damaged. However, this is still the ethical decision, as the public's welfare will be protected. You could also choose to do what the engineers did with the Titanic. They did not report the issue, which led to the failure of the ship and the loss of 1,500 lives. This is obviously not the ethically correct course of action. The legal case would deal with tort law. The first requirement for a case to be tort is that a duty of care is owed by the defendant to the plaintiff. In this case, the captain and crew of the Titanic owed their passengers safe travel on board the ship. The second condition of tort law is that the duty of care is breached by the defendant. The crew failed to provide their duty of care because they ignored at least 4 warnings about large ice flows ahead. The captain and crew responded to these messages by saying, quote, "Shut up, I'm busy." The final condition of tort law is that the damages are incurred as a result of the breach. In the case of the Titanic, there was the tragic loss of more than 1,500 lives and the loss of a vessel with a value of $400 million in today's currency. The plaintiff in this case would be anyone who suffered a loss of possession and the families of those killed in the disaster. The defendant would be the captain of the Titanic and by vicarious liability the owners of the Titanic, White Star Lines. All of the conditions for liability are met by this case. The final condition, gross misconduct, is especially clear. The captain showed a massive disregard for the safety of his passengers and crew when he ignored the cautionary messages. This is backed by the legal precedents of Winnipeg Condos versus Bird Construction, which stated that, quote, "It is obvious that a failure to take reasonable care would pose a substantial risk to the health and safety of the occupants." In the case of the Titanic, the court would likely rule against the captain and White Star Lines, requiring that the captain and by vicarious liability White Star Lines pay the families of those killed in the accident and those who lost possessions. The Titanic disaster was one of the deadliest commercial ship disasters in the 20th century. From the implementation of new lifeboat policies to changes in the way ships were required to respond to distress signals, it resulted in major changes to the way passenger ships were regulated.